Hiya, I'm Laura, founder of D.I.P.ism.com. Coming up next is a conversation that I had with Megan Charles. She is a barrister and she's talking to us today about wills and estate planning. This is a really important video and something you really must think about for the future. There will come a time in all of our lives when we have to approach our death. If we have planned in advance, then we can concentrate on living until that time comes. If you want any more information, you can contact me at www.D.I.P.ism.com. That's www.D.I.P.ism.com. I'm also on Facebook under the group D.I.P.ism. You can contact me. I'm an end-of-life consultant. I deal with the death doula role. I'm also a funeral celebrant, which means that I conduct funerals. I'm a hypnotherapist and a bereavement counsellor. Contact me and let's do this together. Can you just tell me a bit more about yourself before we kick off?
Oh, absolutely. So my name is Megan Charles. I am a barrister, non-practicing barrister, which means I don't wear the wig and the gown and go into court and catch the bad people. But I trained as a barrister. I actually work in financial services and have done so for a very long time, over 30 years. I also volunteer as a citizens advisor as well, and have done that for a number of years. So yes, but I have this very, I suppose it's not really morbid interest in wills and will planning, and I spend a lot of my time trying to asking people, have you got a will, and just trying to encourage them to make sure that they have got those things in place. It's not something people like to talk about, but it is really important. So
it is, and I can honestly say that from life experience, I've had two situations where, one did have a will and the other one didn't. It's vital, it's necessary. And in the work that I do, I'm an end-of-life guide. That includes roles as a death doula and a funeral celebrant and a bereavement support counsellor. So within that, you do come across a lot of people who haven't prepared. And there's a lot of death poverty at the moment as well that is hitting people who just didn't think that they needed to prepare.
Absolutely, yeah. That's so true. I think people think wills are for rich people, and that's so not the case. Everybody needs a will, as long as you have some assets. And if you have children, the chances are you're going to need a will. And I think it's best to be safe than sorry, really.
It is. Okay, all right. So would you like to, I tell you what, I've not made you a host, have I?
Okay.
So what I'll do is I'll just do that. And then when you're ready, if you'd like to do your presentation, that would be fantastic. Yes, please.
Okay, we're good. I'm now the host. Okay, fantastic.
Okay.
All right, so let's do this. Let's share. Everybody's had to become a Zoom expert.
Overnight, yes.
And I'm so not an expert at Zoom, but here we go.
Okay.
Is that presenting?
Yep, I can see. Yep.
Fantastic. Well, good afternoon to everyone and to Laura, and I'm very grateful to Laura for asking me to speak on this really important topic. So, as Laura mentioned, I'm going to speak to you in the next few minutes about wills and estate planning. I think I've already given you a little bit about myself, but this is me, a non-practicing barrister, 30 years experience in the financial services sector, 16 years as a citizens advisor, and I've also advised people on wills and their estate planning and written wills as well for people. So what I'm going to be covering today these topics. I think Laura's going to be jumping in and asking me some questions. Otherwise, we'll cover anything at the end of the presentation, which is great. And any other questions that come through as well, happy to pick those up.
Okay.
So why am I talking to you about this topic? Most people already have a will. A lot of people would think. Well, actually, no, that's not the case. Statistics show that some 68% of UK adults, and that's around about 28 million people in the UK do not have a will. And you might say to me, well, maybe that's 18-year-olds that might be included in that number who think that they don't need a will, perhaps. But we'll come back to that in terms of the age to get a will. But actually over 53% of UK adults over the age of 55 also do not have a will. But personally, I think more worryingly is that 87% of UK adults under the age of 35 do not have a will. And as was pointed out to me, a lot of that's the age group where you would have children. So it's vitally important at all stages, particularly if you have children, to be able to get that will in order. So my purpose, hopefully through this talk at the end of it, is really to make sure that you're in the right side of those percentages in terms of the ones that have a will. So I've heard lots of reasons why people don't have a will. I'm too young. I mentioned that. And in my view, the only reason you're going to be too young is if you're under 18, and under 18-year-olds can't have a will.
Yeah.
So otherwise than that, my view is that you should have a will. And you might think, well, I don't have a house, I haven't got a lot of money. But when you think about it, young people, they start to work. And these days you have something called auto enrollment. So the government automatically enrolls you in pension schemes. And you begin to accumulate money. Admittedly, it's not a lot of money, but it's still money that needs to be assigned somewhere in the event of an untimely death. And young people also have a lot of, spend a lot of their time on the computers and build up digital assets. These two are things that need to be assigned. If there's a value, then they need to be assigned regardless of age. I haven't got round to it, but we hear this a lot. Unfortunately, as we go on, the consequences are in place.
Okay.
It's too depressing. Well, yes, it is. But,
Can I just interrupt? You're breaking up.
Can you hear me?
Yeah, you're breaking up a bit. So what was that you were saying about the assets that these young ones have? If you could just sort of go back a bit. I'm losing you.
Young people, they may think that they're too young to have a will.
Right.
But if you think about it, young people, they start to work and there's a scheme, the government has auto enrollment. That means that you automatically are enrolled in pension schemes. And your employer has to start a pension for you. And so in the event, God forbid, of untimely death, that money still needs to be assigned somewhere. And so, that's something that a young person might need to think about. And also I was mentioning the fact that a lot of young people spend their time online and they may have built up digital wallets. So there may be money sitting in PayPal or Amazon or something like that.
Right.
And that's money that needs to go somewhere. It's their money under their name. That's money that needs to be assigned somewhere in the event of somebody's death. And we'll talk a bit more about digital assets as we go along.
Okay.
I was also mentioning that people say another reason why they don't have a will is that they haven't got round to it. It's very important. We'll look at some of the consequences of not having a will a bit more later on. It's too depressing. Yes, it is. It's not a very exciting or a joyful subject. But gosh, imagine how much more helpful it will be for your loved ones once you're gone, and they don't have to deal with that issue of your estate when you're gone. And you know, it's caring for it's caring for them now, putting things in place and making sure that you're caring for them even after you've gone.
Yeah.
Some people say, well, I don't need to do a will because everything will automatically go to my partner. This is true for the most part, but you really need to also think about, do you want everything to automatically go to your partner? Are you living with that partner now? And so those are questions that you need to think about. It's too expensive. Well, actually, no, it isn't. Doesn't have to be expensive. It may be more expensive depending on the complexity of your estate. If you've got lots of houses, lots of land, that might build into making a will a bit more complicated, but it doesn't have to be expensive at all to write a will. And in fact, you can actually write your own will. You can do a very much DIY will.
Okay.
There was a while ago, I think W.H. Smith, I'm not even sure if they're still trading, I think they are, they were doing DIY will packets. So you can actually do it yourself. I suppose I ought to say that it's best to get an expert, but I think in the interest of full disclosure, I should say that you can actually do it yourself.
Okay, okay.
And a lot of people also say, I don't have a lot of money. Well, none of us really do, unless you're one of the elite rich people. But you do need to think, I mentioned it in terms of the young people, and it's so much more important for older people when you think about all the years that you've worked and the pensions that you've built up. You know, you may even have shares that you didn't even know that you took out, shares in companies that you think you didn't realize you had. All of those things need to be assigned to somebody in the event of your death. Okay. So you may not have money sitting in the bank or in your hands, but you do need to think about the money that is flying around in the ether that actually belongs to you, and you should pass it on to your loved ones as well.
Okay.
So somebody might ask me, well, why do I need a will? You're telling me I do. Why do I need a will? Let me ask you a few questions. I would say, well, are you married? Do you own your own property? Do you have a partner? Do you have grandchildren or even new grandchildren? Do you have children from a previous relationship? And finally, do you want the state to have a say in what you do with your property and your affairs? So you may have answered yes to one or more of the first 5 questions and hopefully no to the final question. If you have answered yes to any of those and no to the last, then you need a will. Chances are that you'll definitely need a will. You need to think about putting that in place. So let's look more closely at what a will actually is. So a will is simply a legal document. Document that tells everyone what should happen to your money, possessions, and property after you die, and who should manage the distribution process. To be valid, a will needs to be in writing, and it needs to be signed by the person making the will in the presence of 2 or more witnesses, who must also sign the will at the same time. And those 2 witnesses shouldn't be somebody that will benefit from the will or get anything as a result of that person dying. Right. So they won't be named in the will.
Ah, okay.
Okay.
That's interesting.
So let's look a little bit about what actually goes into the will. So assets. And these are things like things that belong to you. They're yours, your possessions. So they may be money in the bank account, you know, any shares I mentioned that you might have, any BT shares flying around that you may have, your cars, any personal belongings that you have. These are your assets, things that you own. And these are things that you can put into your will and say, I want so-and-so to have this, and I want that other person to have that. And those are things that you put in. Real property, this is a sort of a legal term, if you like, and that's talking about the actual bricks and mortar, your house, where you live, any land that you may have as well. So it's actually physical dirt and bricks and mortar. So that's real property. So that also goes into your will, and you assign that and say who should get that.
Okay.
Another really important aspect that needs to go into a will, if it relates to you, is guardianship for any children that are under the age of 18. Obviously, once you reach 18, you become an adult, and you don't need to sort of have that person necessarily looking after you. But it's important to put this in your will, who you want to look after your children that are under the age of 18 in the event that you die. And it's extremely important, obviously, that you think about the person very carefully, person or persons, it could be more than one, who should do this, who should look after your children. Think about that person. They're going to be stepping into the role as a parent, and they're going to pick up those parental rights that people have, and that people have as parents, and parental responsibilities, including to make sure the child is looked after, is fed, is clothed, and gets a good education, or gets an education. So these are all things that a guardian would need to do. So you need to think very carefully about who does that.
Sorry
put
to
that in the will. No, that's fine.
I would have thought that would be the role of the godparents. Well, not everybody's christened, are they? But that's normally what people think about when they are christening their children, isn't it? Like, who's going to look after them in the event of their demise?
I think they do, but actually, I don't know, maybe godparents would be maybe pleased to hear that it's not an automatic role that they take on.
Oh,
so
right.
It does have to be legally assigned, and the child handed over. That sounds awful, as though they're a bit property, but the child has to be legally handed over to the care of an individual, and it isn't necessarily the godparents. Could be, but that doesn't happen automatically just because you're their godparent.
Okay.
Godparents breathing a sigh of relief everywhere they've got these children. But no, but yes, it could well be something that you, it could be the person that you think of, but they would need to have that assigned to them legally.
Right, okay.
The other people that go into your will are your beneficiaries. These are the people that are actually going to benefit, hence the word, from your will. So the people that will get your car, or they'll get your shoes, or they'll get your favorite painting. These are your beneficiaries. The other important area is your executors. Now, these are very important. These are the people that are actually going to make sure what you've said in your will actually happens. They manage the whole process. Now, you can actually also have professional executors, and you can hand that over to people. So it could be the people that write your will, and they can, you would then pay them in the event of your death to make sure that what happens in your will happens. Because it can be quite an involved process, and it can be not necessarily time consuming, but I suppose when you think about it, although you'd have to pay a professional executor, they're almost removed from the process. So if your executor is a friend or one of your children, they're dealing with the grief of your death as well. Right. And they're dealing with all of that. So maybe you think, well, let somebody else who isn't emotionally involved. So that might be a reason why you might think to have a professional executor. But other than that, your executors can be the beneficiaries as well. I think, I believe my sister, my brother and I are the executors of my parents' will. So, and we would hope that we would be beneficiaries as well. So your executor, your executors and your beneficiaries can be the same. They're not mutually exclusive.
Okay.
So they also, yeah, and you need to think very carefully again about your executive as well, executors. Make sure they're people that you expect to outlive you. no good having an executor who's going to sort of,
who's already
the
gone,
same age as you, who might die, you know, the day after or the day or before or something like that.
Okay.
So.
Right, okay. I've got somebody in the chat who has said that she has written her own will.
Okay.
Yeah. So I suppose, you know, in line with what you've said, just as long as everybody knows where that will is, it does stand.
As long as everyone knows where, and you know, often you can write your own will if your life is really, really simple. Maybe you don't have it. I'm not saying that you know, it might be you don't have any children, or you have children and your life is not necessarily complicated.
Yeah.
And it's got straightforward. When I die, whatever I have will go to my two children, and that, yeah, really, really simple. Okay. It can become more complicated when you've got lots. You might have another children from another relationship, or different properties, or all these things that can complicate. But yeah, absolutely no reason why you can't write your own will.
Right. Okay.
So yeah, well done. Fantastic.
Yeah.
The other thing as well that I'd like to just briefly touch on is what might go into a will. And this has become more relevant in recent years as we begin to live pretty much most of our life online in some way, shape or form. And that's your sort of digital estate that people have built up. And we build up what are called digital assets. So obviously your assets form part of your estate, as we've mentioned above, and those are your sort of physical assets, but you can also have digital assets. And these may be things like your email, software, data, it could be cryptocurrency, any online accounts. Now, not all of those can be left to people in your will. The bottom line really is, if there is some value to your digital assets, then it can actually probably be left in your will. So when I say that, what I'm talking about are things like, if perhaps you have a PayPal account and there's money in there,
right?
Or
okay.
Amazon owes you some money for something, that sort of thing. You might have air miles. If there's any value, and it needs to be, and it can be assigned, and then is, you know, it's a digital asset, then it can be assigned to somebody in your will. There are some things, some digital assets that can't be assigned. So for example, if you've got, you know, lots of followers on your Instagram or whatever it is, and you think, oh, I'd love my daughter to have all my followers. You can tell I don't know about Instagram, but you can't assign those people to your daughter. That's not something, you don't own those people, you don't own those followers. Things like Netflix accounts, you can't assign those either, because really those are, you know, the things that you may have bought through Netflix or anything like that, they're actually owned by Netflix. Netflix allows you to use them. So those are things that can't be put into your will.
I suppose it's more like renting, really, isn't it? When we think about Netflix or accounts that we have with these companies, we're just renting their product, aren't we?
That's right, absolutely. You know, if you're sort of, you get a license to use them, but that expires once you die and it can't be passed on.
Okay. And as for the followers, we can't take them with us.
I'm afraid not. No.
Okay.
So having said that, let's look a little bit about what actually stays out of your will, definitely.
Okay.
Now, overseas properties, if you're fortunate enough to have a nice holiday home somewhere, Costa Brava or something, or in the Caribbean, or you have perhaps some land in the Caribbean, it's not something that is easily left into your will. You can have a provision in the will that says all of my worldwide assets. But the problem with that is you need to make sure that it's compatible with the legal requirements of the country where that property is. Okay. So for example, you need to make sure, if it is in Spain, for example, whatever you've written in your will needs to be compatible with the Spanish law. There may be different rules of inheritance, for example, that you need to think about. So it's a bit difficult to automatically say that my property in Spain will be passed on to whoever. The best thing to do is to get perhaps speak to somebody in Spain and get some sort of negotiation between two solicitors, so that they can understand what is in the will and see whether it's compatible.
Okay.
So essentially I'm saying, so take some advice of perhaps a specialist in overseas wills, overseas assets, in the event that you need to make sure that that is covered in your will as well.
Okay.
Gifts with conditions. So these might be things like saying, I'm going to leave Jenny £1,000, but only if Jenny gets married by the time she's 21. You can put it in there, but the problem is that it could become void. And what I mean by that, unless you've got one of those professional executors that's going to follow Jenny around and find out what she does with her life, right. It's very difficult to enforce that. So it's not that it doesn't make sense, but it's difficult to sort of enforce it. So don't complicate the will by putting things in there that may be difficult and may become void if they can't be followed through. So that's something to think about. Gifts for pets. Now, you might love Rex more than you love everybody else, and Rex is the only one that's always there for you. Your children don't even come look for you. And you're going to think, right, I'm going to leave everything in my life to Rex. That would be nice, but pets, actually, animals can't own property. And so
sorry,
I wouldn't recommend leaving the house to Rex. What you could do perhaps is make provision for him in the will, either that he goes to live with somebody who will look after him, or that he goes to perhaps a pet home, but that you have financial provision in the will to care for him.
Poor Rex.
Funeral plans. And by this, I don't mean, the funeral plans that you see them popping up on the TV talking about taking one out. This is more along the lines of, what you want to happen at your will, your funeral, sorry. So that might be something like, what dress you want to wear, or what songs you would like sung, that sort of thing. Now, you wouldn't typically put that into the body of the will itself, but you might put it into something called a letter of wishes. And this is something that you would include, and it is an actual letter that it needs to be signed by you. It doesn't need to be witnessed, but it does need to be signed by you. And it will just sort of gives you an opportunity to express additional information that may be useful for your executors. So so I mentioned the digital estate. One of the things that's important, if you do have digital online accounts, and maybe put in information as to how the executor can access that information. That's going to be very important, and would, speed up the process, because obviously we've all got passwords, and it's so difficult now, as it should be, to get into other people's accounts. So that might be information you could put in there. The other thing that might go into a letter of wishes, any information that is peculiar about your children, if in terms of guardianship, you might say there are special ways that they need to be treated. That's something that you would perhaps write into a letter of wishes.
Okay, diets and allergies and stuff like that. Okay.
Absolutely, that's perfect. Yeah, that sort of thing perhaps could go in there. So as I said, funeral plans typically would go there. Any songs, I think my mother's already laid out what songs she wants sung at her funeral, that sort of thing. So that's where you would put that.
Okay, and as a death doula, under that role, my role would be, I would be able to sit down with people and just help them to draft this letter and
Yes.
go through it and just ask them those questions. You know, what would you want to experience at the end of your life? It's like an advanced plan.
Definitely.
We don't know, nobody knows when we're going to die, but if we've at least got a plan in place, then it just helps those who care for us to know how to prepare the area, and what dress you want to be buried in, and you know, what music you want to be played. Actually, it's funny you should say that, letter of wishes. So I posted a video a few days ago of a gentleman who was speaking in Australia, and he's like a funeral disruptor. And so he goes to a funeral and he says, you know, listen to the dead man is speaking, and he's got a list of instructions in there. So he'll say, you know, Jack, Jill, Mary, you've not seen him for 30 years. He wants you out. Go. What's interesting is that since I've put that video out, I've had 2 people say to me, you know what, I hadn't thought of it before. There are certain people that I don't want at my funeral, and there are certain things that I do want to happen. So a letter of wishes, just to let everybody know, a letter of wishes is that's the way forward.
Absolutely. I mean, I often sort of say, when I do presentations, the first thing in my mind, oh, don't put anything horrible in your letter, you know, but actually you can put what you like in this. So it's your wish. So whatever, perhaps, so whatever you want to happen, you can use that to put it in there.
Right, okay.
Fantastic.
Have it your way.
That's right. So what I really, really want to obviously cover is what happens if you don't have a will.
Right.
So if you don't leave a will, the law decides how your estate is passed on. It's not that they come in and burst through the door and so, but there's a legal order, if you like, to how your estate is passed on. And the problem with this is that it just may not be in line with what you want to happen. So the will, writing a will, gives you that right now to say what you want to do. But what happens is whatever you leave becomes subject to the law of intestacy. So what is intestacy? It simply means that you died without a will, you died intestate. Okay. And the law decides a certain way what happens. Now, in most circumstances, the law of intestacy works the way that you want it to work. So, for example, if you have a spouse or a civil partner, you don't have any children, your spouse will, or civil partner will inherit your entire estate, and they'll get all your personal possessions. Now, and that's fine. If you're living with them and you want that to happen, that's absolutely not a problem. Or perhaps you have children and your spouse or partner is already deceased. Your children will get everything and it will be divided equally between them. And you might say, oh, my children love each other, so there's going to be no problems, and they're all going to divide it equally and everything's going to be fine. And if you can be assured of that, then, you know, I'm not advocating intestacy, of course, but I'm saying that it works the way that you would hope that things would work.
Yeah.
And that's great. So let's look at a scenario then. Jennifer is married to James. They don't have any children. Jennifer dies. She didn't make a will. The value of her estate is over £300,000. I'll explain why that's relevant in a bit. Under the rules of intestacy, James inherits all of Jennifer's estate and all of her possessions. That's absolutely fine. That's what Jennifer probably would have wanted. Okay. Problems start to arise if your life is a bit more complicated, and some people's are. You know, it's the case that, you know, you might have, if you're not married and not in a civil partnership, your partner is actually not legally entitled to anything when you die. So in the past, you may have heard the term common law wife or common law husband. That's actually not recognized in law. If you're not married to them, chances are that they're not going to inherit anything from your estate. Maybe the case that you're married but you're separated, your husband or wife could inherit most or all of your estate. and any children you have, they may not get anything, or they may get very little.
Right. Okay.
Or if it's the case that you're divorced and perhaps have remarried, and you have children with your first partner, your children from your first marriage, in the event, depending on the rules of intestacy, may not get anything as well. So that's another reason why it's really, really important to get a will.
Okay.
And I say this because, and I'll explain why, the intestacy rules work in a certain way. So it means that they're divided in a certain way. If you have a spouse or a civil partner and children, your spouse or civil partner will inherit all of your personal possessions, so all of those, paintings or whatever it is you have, and at least the first £270,000 of your estate. So they automatically get that. And then they get plus half of whatever's left. Your children will then be entitled to the other half of what's left. Let me explain that with a scenario. So Peter was married to Sarah, and they adopted a daughter called Julie. So Julie's their daughter in the eyes of law. That's fine. But Peter and Sarah separated some 15 years ago. Peter met, and he was living with Prudence, but they didn't get married. But Peter then died without a will, and his estate is worth £450,000. Because Peter didn't write a will, his estate has to be decided under the intestacy rules. Sarah, the lady he left 15 years ago, not separated, possibly didn't speak, I don't know. Sarah automatically inherits that £270,000 from Peter's estate and his possessions, all of his possessions. That leaves £180,000. Sarah also gets half of that, 90,000. Julie gets the other 90,000 that's left, and Prudence doesn't get anything at all.
Right. Okay. Right. Okay. Prudence is left with the memories. She has the memories.
Prudence has only got the memories, but yeah, I imagine Sarah will be coming and whatever. So let's look at one more scenario. Alan and Grace were married, and they had 2 children, Tim and Annie. Alan and Grace got divorced, and then Alan found Barbara, got married, and they had a child called Mark. Alan didn't leave a will, and his estate is worth £250,000. Under the rules of intestacy, Grace doesn't inherit because under the law, her marriage is dissolved, and she's no longer a partner of Alan. That's fine. But Barbara gets everything. And because it's less than 270, everything's handed over to her. Alan's other children, Tim and Annie, whom perhaps I'm sure he would have wanted to get something, they get nothing because everything automatically goes to Barbara, his wife.
Right. Yeah, that's the situation that I found myself in. So in this situation, my dad is Alan, and he married Barbara. Barbara changed the locks within 2 days of his funeral.
Oh, no.
And that was that. She inherited absolutely everything. If Alan had made a will, then it would have been different. But
Yes.
as well, a lot of us think to ourselves, I don't have anything. Or, as Maxine has said, she's mentioned the word integrity in the note.
Yes.
You think that Barbara will have some integrity and,
Exactly.
in inverted commas, do the right thing. But it's down to the person, isn't it, to do the right thing, make your will and have it stated.
Yeah, don't leave it up to people's good nature because they just may not have one. So it's best to get that in order. So what happens? You can't argue with a will, and as long as you can find it, and as long as it's legally correct. So make a will.
Okay. I'm not bitter. Don't worry, I'm not bitter. Okay.
So, just a quick word on tax. The other reason to make a will any inheritance tax that your estate has to pay may be higher than if you had made a will. So, you know, we don't want to give the taxman more than, you know, he's legally entitled to get. That's absolutely fine. But, you know, if you can make sure that you give the right amount, then you should do that. And a will help with that. So you don't have to give more than you need to give. The other thing to consider, which is always quite shocking, if you die with no close relatives, the entirety of your estate, and you don't have a will, the entirety of your estate will belong to the Crown or to the government. So that government that's taken so much from you during your life, and the Queen, who already has so much, is going to could potentially take your property if you don't make a will.
So with this, is this inheritance tax where we talk about nursing homes? If you go into a nursing home, if you find yourself there,
that's something to do with trust. I'm just going to come on to that now.
All
so
right.
we'll talk about that. So yeah, quick word on trusts. So a trust is a legal structure which can be included as part of your will. So it's actually not a sort of a real thing, but it's a legal structure. And it can offer increased asset protection for your loved ones. Now, they're really complicated, but they're commonly used in the circumstances where perhaps you want to protect your estate against any possible care fees, or in one of the scenarios that we spoke about earlier, you have a spouse or a partner, but you have children from a previous relationship, and you want to make sure that your property or your assets pass on, or the children from that previous relation get something. So, I mean, dealing with the care fees are perhaps quite relevant in our current circumstances. It may be the case where, because if you have to pay for your care, and anybody who has assets or capital over, I think it's £23,000, £23,500, if you have money above that level, then the state deems that you are able to pay for your care. And the possibility is that they may require you to sell your property to pay for that care. And so in order to perhaps ensure that your home is protected for your children, you can set up a trust in your will, so that perhaps if you have a spouse, what you might do is say one of you goes into care home and the other one stays in the property. If any of the house needs to be sold to pay for that care, only 50%. By putting it in a trust, what you can do is protect 50% of the property, so that the care home could only take that 50%. And the other part of the house would be protected for your children, and that could be passed on in their inheritance. So not all of the house could be sold to pay for the care fees. So that's a really good reason to have part of the property in trust. Care fees are so expensive, and you know, with people living longer, we don't know how long people may have to go into a home if, you know, unfortunately they have to do that and stay there permanently. Those fees will mount up. How do you pay for them? Possibly by selling the property. There are lots of rules that sit around it. We can't sell. So if you're married and you're in a care home and your husband is still in the house, they can't sell the property out from under the husband, but they can almost, if you like, put a charge on it in a way, so that some of the money will, you know, be so, once it's sold, perhaps that money will go towards paying for those care fees.
Wow. Okay.
So trust. I think you know, I read a lot of historical novels, and they talk about trusts, or the rich people do, and you think it's something only that rich people set up trusts for their children. But you know, everybody can and, you know, should use them, really, and they actually also help with inheritance tax as well. They can they can limit the tax that you have to pay if you put something into a trust as well.
Right.
So they're very useful tools.
Okay, and so to create a trust, you just go to a solicitor and just get that drawn up.
Yeah, you can get that drawn up. You have to have a will to have a trust.
Right.
But yes, so get a will, another reason to get a will.
Yeah.
Get a will, and then you can get a trust put into that will. You don't need them in all circumstances. I mean, I've outlined a couple here. I don't have, I'm not married and I don't have children. I don't have a trust in my will. I don't really need one. Okay. But depending on your circumstances, then they may well be good to have a will, a trust in your will.
Right, okay. Wow, okay.
And just a quick word on inheritance tax, as I was talking about that. As I said, you know, it can be limited if you put things in trust, or indeed having a will in the first place can help to manage the amount of tax that you have to pay to the government. You know, we pay tax all through our lives. You know, you really don't want to have to pay too much when you die.
Yeah.
So inheritance tax, sorry. Is that okay? Yeah. Inheritance tax is a tax on the estate or the property and money of somebody who dies. And it only needs to be paid in certain circumstances. The standard inheritance tax rate is 40%, but it's only charged on the part of your estate that is above the threshold. So let me give you an example. Your estate is worth £500,000, £500,000. You have a tax-free threshold of £325,000. And what that means is anything below £325,000, you don't have to pay tax, which is great. The inheritance tax will only be charged on the amount above that threshold. So in this case, on the £175,000 that remains. So you charge 40% on that. There's normally no inheritance tax to pay if the value of your estate is below 325, as I've said. If you leave everything above the 325 threshold to your spouse or your civil partner, or if you leave it to a charity, you don't have to pay tax on that. So automatically, if it goes to your husband, then you don't have to pay tax. Or if you give away your home to your children or your grandchildren, your threshold can also increase as well in terms of the amount of whether below which you have to or above which you have to pay tax.
Okay, so I've just got two questions then. So Nancy goes into a care home.
Yeah.
And then when the time comes, they're going to take the money for her care. And then whatever's left over, if it still comes over over the threshold, you're going to have to pay 40% on that as well.
Potentially. I mean, if it depends on what happens. So if Nancy's husband is still alive, yeah, everything goes to him.
Right.
And he doesn't have to pay tax because essentially it becomes part of his estate.
Yes.
The other thing is that Nancy can also hand over, if you like, her tax-free allowance to her husband. So he then gets the tax-free allowance actually of £650,000.
Okay.
So she can kind of hand that over to him as well. So he would still have to pay her debts. So he may have to pay her care home fee debts, but she sort of gifts him, if you like, her tax-free allowance. So it may be the case that he doesn't have to pay any inheritance tax on because it goes up. So his threshold rises.
Okay. So is it possible then to gift your house to your children? Can you do that?
You can gift your house to your children while you're still alive, you mean, obviously.
Yeah.
So
to avoid all of this.
Yeah, you can give gifts to your children or to people that you think that particular asset perhaps may attract inheritance tax when you die. But you have to be careful. You have to make sure that to avoid inheritance tax or to minimize it, because there's sort of like a sliding scale, you have to give that gift. There has to be a gap of 7 years between when you gave the gift and when you died.
7 years.
7 years. And the amount of inheritance tax reduces throughout the year. So if you gave the gift, say in, let's give year 2000 for ease, if you gifted somebody your property in 2000, but you died in 2004, or if you died, well, let's go this way, if you died immediately, unfortunately, you'd still have to pay inheritance tax. But if you manage to hang on for about 4 years, you still have to pay inheritance tax, but it's slightly less. There's a sliding scale. I think it's by that time it's going to be about, I can't remember, it might be about 20%. By the time you get to, if you have managed to hang on for 7 years and you've gifted your property, then there's no, past 7 years, there's no inheritance tax to pay. So right. That's another way to go about it. You maybe want to think about gifting your property now at this stage, or other assets as well that you think might attract inheritance tax. That might be a way to go.
Right, okay.
And that's something you can do. You have something called a £3,000 gift allowance as part of your tax that you can give throughout your tax year. So you can gift up to I think £3,000 in a year of different assets. So you can do that.
So gradual. You can do it.
Yeah, absolutely. And you can gift also little things up to a value of about £250 with no tax implications at all. So you can do that, little gifts. So yeah, there are ways. I'm not advocating tax avoidance.
No, absolutely not. No.
But there are ways to manage, and I think that's important.
Yeah.
Okay, and I've mentioned that you can share some of your tax allowance with your spouse. So I'd like to just give a last word on lasting power of attorney. And these are really important, and they're often referred to as living wills, but the actual legal technical term is a lasting power of attorney. And these are legal documents, but they're really important in the event that you might become, somebody might become incapacitated either through illness or for some other reason, or might lose mental capacity, and they're not able to make decisions for themselves.
Right.
So what this allows is that you, in this lasting power, you hand over authority for somebody to make your decisions in some aspects of your life.
Okay.
Now you can have two types of lasting power of attorney. You can have one that deals with your health and one that deals with your finances. They're separate. Some people you can have either or, but obviously it makes sense to have both. And this allows, it's really useful. As I said, if you're, going to hospital, you become unconscious, but there are bills to be paid. It gives that person that you've given that authority the right to go into and, take money from your account, not take money, but, use your accounts and make those payments. It shows that you have authority to do that. So on that basis, having said that, it's very important who you assign to be your attorney. Now it can be your husband or your wife, can be your spouse, can be your children as well. And you can typically have as many people as you like. 4 is usually sort of standard, if you like, but it doesn't have to be 4. It can be 1 or 2. But you need to make sure that those 2 people can agree for starters, and that that if one of them dies, or you have enough to cover, also in case some people pass away or something like that, but that you've got other attorneys that can pick up that role. So yes, very important to think of trustworthy people that you know will act in your best interests, either in terms of your health or in terms of your finances. They're very easy to set up. It's a matter of completing a form which you can download, and you just need to get people to sign it. You need to get people to witness it as well. In terms of cost, they're about, at the last few that I did, they were £82 each, and you need £82 for the health one, £82 for the finance one. Also, if you're married, you can't have a joint lasting power of attorney. Your husband would need to have his own, and you would need to have your own of both types. So essentially, you'd have 4 powers of attorney in the house. But your husband can be your partner, your power of attorney, and you can be your husband. So yeah, so really, really useful. And it's all part of that estate planning. You just don't know what's going to happen. If you've got this set up, it just makes it easier for your family to be able to deal with your affairs and have that access to deal with your affairs as well. Okay,
just a quick one. So I know you said that you can have 4. You can surely, like, if Tom and Nancy go skiing in the Alps, and there's an avalanche, and they're both in a situation where neither of them can speak for the other. Is it really better that each of the couple have their own separate power of attorneys?
Yes, they do need to have their own separate power of attorney.
Right.
And this is why you have maybe up to 4, at least more than 1.
Right.
So
okay.
For that very scenario, if your husband is your power of attorney and you're your husband's, you both die, then and if you've got thrown to the mix the fact that you've got children underage and that sort of thing, under 18, all of that becomes really complicated, and you want somebody to be able to, you don't die, but you're both in hospital and nobody can speak. You need somebody to be able to sort of pick up that information. So that's why it makes sense to have more than 1 power of attorney. So your children might. So I did a power of attorney for a family not too long ago. The husband was the first power of attorney for his wife, but then they had 3 children, and the 3 children were also attorneys as well. So there were 4 of them.
Okay, so it looks to me that this is something that is best done before you get sick, before there's even any thought of dying, or do it now.
Absolutely.
Whilst you're in
Definitely.
Your health. Don't wait till the last minute.
No, absolutely not. It's good estate planning. This is all part of it. As I said, you don't know what's going to happen. It's a bit of, and you can also, you don't have to wait till it's not something you have to wait for that you're sick. It could be, I could potentially take my power of attorney, my mum's power of attorney, to the bank so that I can look after her affairs for her. She may just not be able to do it, but I can show the power of attorney to the bank, and I can say, well, let me pay these bills on behalf of my mum. Mum is absolutely compos mentis, nothing wrong with her. She just can't go to the bank, and she wants me to deal with it for. So you can use them now. They kick in. As soon as you write them, they kick in.
Right.
And you can use it. You don't have to wait till somebody can't speak or think.
Or I suppose if towards the end they're becoming confused, maybe they've got Alzheimer's or dementia, it can be a really traumatic time for the family. And I suppose getting them to then just sign the documents will be a struggle, especially if they think, oh, you're trying to steal my stuff, If it's
Absolutely.
done beforehand when everyone's compos mentis, then it's all good, isn't it?
Yeah, because there's a question in one of the forms that says, does the person have mental capacity? So you can do it at that stage, but it's just so you have to then prove, have they lost mental capacity? Do they still have it? And that's just added trauma to the trauma that you're already dealing with. So yeah, do it now. Do it now when they know what they're doing, you know what they're doing, and it's just there.
Right.
Insurance policy for what might come.
Okay. Okay.
So just a few last thoughts from me. Did you know that in 2014, £8 million worth of property reverted to the Crown because people died intestate? So the Crown and the state who own so much land, they got even more because people's hard-earned property, because they didn't write a will. In 2016, 75% of people surveyed had not reviewed their will in the last 10 years. And you know how much can change in 10 years.
Yeah.
And so if you've had children in that time, looking at some of the scenarios we looked at, whether you got divorced and all sorts, if you haven't reviewed your will, it just could be a nightmare waiting to happen. 6 in 10 parents don't have a will, or have one that is out of date. So again, if you've had, if you're under 35 or quite young and having children, you don't have a will, you need to think about that. You need to think about, if you just don't know when you're going to die, unfortunately, are your children, is their guardianship prepared for them in the event of your death? And in 2013, a survey revealed that 67% of UK residents didn't know the location of their parents' wills. So it's all very well writing a will, but if nobody can find your will, then, and it hasn't been registered, because you can register your will, but if it hasn't been registered and you've hidden it under the floorboard or sewn it into the mattress or something, nobody's going to look there. So you may as well not have it if nobody knows where it is. So
that's
important to
sorry to interrupt. That was actually a question that came up from Maxine in the chat. Can you always find the will? And is there a central place of registration? So could I write my will and then put it somewhere and it's safe, and that's,
You can. Now I think there's a story. It's the will. There's a will registry. Now I believe there are some places where you can pay to have your will stored, pay yourself, so you can write it yourself and then pay to have it sort of registered so people can find it in the event of your death.
Okay.
Sometimes when solicitors write them, they do that for you, and they will hold your will as well.
Right.
So they will have a copy of your will sitting in their vault or on their computer or something like that.
Okay.
But very important, if you write your will yourself, make sure people know where, and you don't want to pay for any storage.
Yeah. And
write it yourself.
Could your executors have a copy?
That's an excellent idea. Yeah, absolutely. Okay. Give your executors a copy of your will.
Okay, so definitely. What happens now, right, if Marva, she's written her will and she hasn't told anybody where it is, right, because she doesn't want everyone to get her money, trying to kill her off. So then she dies. There's now a risk that her everything is going to go interstate, but there's a will. She wrote this will. It will go interstate, so it will become part of this, this accumulation that the Crown is accumulating. What then happens, do you know, if the papers miraculously turn up? Is that possible? Like, it turns up that they were under the floorboard, in the shoebox, under her bed, with the gold? Well,
I mean, everything would, when you die without a will, even when you die with a will, you have to go through probate. A will makes all of that easier, and probate is another whole topic by itself. Okay. You probably, potentially, if the, so with Marva, if Marva's circumstances are such that she had children from another relationship who didn't inherit under this will.
Yeah.
But in the will that was actually written, these children were accounted for. Potentially, these children could make a claim, having found the will, they could then make a claim against the estate. You'd have to go through the courts probably.
Yeah.
But yeah, I mean, if the will miraculously appeared and it was verified, then yeah, claim could arguably be made.
Okay.
Yes.
If it turned out that my dad actually had written a will on the back of a little Rizzler paper, oh, quids in. Okay.
As long as it's signed by 2 people, yeah.
Okay.
On the Rizzler paper, yeah.
On the back of the Rizzler. Okay, so you've also got here that 59% of parents don't have a will, or it's out of date. So at what point does it become out of date? Is it when new stuff has happened, say within that 10 years? Then
absolutely. Any sort of, yeah, any life-changing event. So you have a, the law will deal with, if you have a will, the law will deal with the last will that they find.
Right.
That appears to be signed and as is valid and in order. So
right.
If there's a will that's signed by you and it's signed by 2 people, seemingly at the same time, whatever is in that will be taken as your last will and testament.
Right. Okay.
So yeah. So if you have a life-changing event, you have a new child, or you get married, or I don't know, you have new grandchildren that you want to make sure are catered for, or you get divorced and you want to make sure your children are covered, then yes, you need to update your will. I can't say do it every couple of years. You might want to, but every time, think of it, every time there's a significant event in your life,
yeah,
you need to think about checking your will. Does it fit my circumstances as they are now?
Wow. So it's a live and living document that we should really keep up to date. It's really important. Okay.
Absolutely.
And I've got a question here in the chat. If you write your own will,
yeah,
do you still need 2 signatures? 2 witnesses to authenticate it?
A will, to be valid will, it has to be signed by you and signed by 2 witnesses.
Right. Okay. Wow. There's a lot to it, isn't there?
It is. My key takeaways, or hopefully your takeaways: make a will. And lasting power of attorneys, if you think that might be necessary. Ensure it reflects your wishes and it fits your circumstances as they are now. Review it regularly, and for goodness sake, make sure people know where it is.
Right. Okay.
Put it in the bank, in a deposit, I don't know, where there's safety deposit boxes or something, I don't know, but make sure people know where your will is.
Right. Okay.
Yeah.
Gosh. That has been amazing. Please do, literally. So what I'm seeing from taking a few points for myself.
Yeah.
Make the will and do your lasting power of attorneys, and do your letters of wishes as well.
Absolutely.
And if necessary, do trusts as well. So if you sort those 4 things out before you are even ill, when you come to the moment when you are told that you're terminal and that there's nothing they can do for you, this is one less huge boulder that is off your shoulders.
Absolutely. And your family as well.
And off your family's shoulders. Absolutely. So that at that time they can actually prepare you and be with you, taking care of you. You get their full attention. They're not out here running around wondering what they should do and who they need to go to. Also, as well, doing it now means that you can actually live. You don't have to be worried. You can actually go out and live your life and enjoy your life, knowing that when that time comes, you're good. You're good.
Yeah.
Right. Okay.
Absolutely.
And I think another thing that I've kind of picked up on is that it's probably a good idea to get married. Seems to be
Yeah. Yeah, tax reasons it is, yeah.
Yeah, financially beneficial, maybe. Okay. So Megan, thank you so much. We've got some
You're very
questions and
welcome.
stuff in the chat, so we'll just sort of go through
Yeah.
them. We've got some
Okay.
comments. Yes, so at the beginning, I was wondering whether we were live. We were live. And we've got the sister here that says that she's written her own will. So Maxine has also said that when you're choosing your executors, you have to make sure that they are people of integrity.
Yes.
Yep. And she's also mentioned about, can you always find a will? Is there a central place of registration? So it was Yvonne who said that it would probably be a good idea for it to be kept by the executors, and you give a copy to the beneficiaries as well.
Yeah, absolutely. I think that's very sensible, excellent idea.
Right.
Yeah, I mean, either give them a copy or show them where the real one is.
Yeah, that way.
Definitely, no.
Yeah, nobody can then sort of say,
sense.
That's not the one that I saw. Yeah. So
but that's the thing. I mean, the only problem with that, you need to make sure if it changes, that everybody then gets a new copy. So yeah.
Yeah. Okay. So Natalie, that's something that Natalie had worried about in the past. Yvonne has said, I definitely do not want a particular young woman at my funeral, and she will be, yes, Yvonne, she will be asked to leave. Yeah.
Wow.
If she dares to show her face, she'll be shown the exit. Okay. So if you write your own will, do we still need the signatures? Yes, 7 years before you die. Right, yeah, okay. So there was a little conversation that went on about not knowing where the will is. So an experience here, my uncle's wife produced a fake will when we were sitting there with the copies of the original.
Wow, that must have been embarrassing. Oh my goodness. Okay.
She wanted everything with no sharing. Yeah. So yes, and that's a criminal offence.
Yeah.
It's a criminal offence to fake a will.
Absolutely, definitely, yeah. Definitely. I should think it would be, yeah.
Right. Okay.
I don't know the exact law that's been broken. I can certainly find out, but it sounds like fraud to me. But yeah.
Right. Okay. All right. So the next question was, what makes a will out of date? And we answered that. So it's just basically keep on top of it. Milestones, life changes, family changes, any changes, just keep going over the will. Keep it live as you are.
Yeah. That's what we mean by out of date. It's not that it kind of has a life shelf life. It's just the fact that, you need to think about, has anything significant changed? Is anybody that I want to benefit, will they not benefit as a result of the will I have currently?
Right. Yeah. Okay. And if there is anybody who doesn't need to be in there anymore, then, they can be exchanged for somebody else.
That's interesting, that one. It's not quite disinheritance, but in a way it is. You can kind of disinherit people, but if that person feels that they have an entitlement to part of your estate, then they could actually put in a claim to the courts and say, actually, I am entitled to a bit of this estate.
Okay.
And the courts would have to look at that. So yeah, you can sort of say I'm disinheriting my children because
you don't like their lifestyle or something.
Yeah. But actually, they can then say to the court, well, no, actually, I'm entitled for whatever reasons. They'd have to present reasons to the court, and the court would look at that and reconsider potentially.
Right. Okay. I was just going to ask one last question. When Michael Jackson died, apparently he died broke, but he is now worth trillions and billions more now that he's dead. Is that like a common thing then, that a lot of people are sort of cash poor, but upon their demise, that's when they become,
well, it's
healthy.
possible, you know, that they may have asset. I imagine Michael Jackson is rich as a result of his royalties. I think Elvis Presley is similar, that sort of thing, and copyright. So, for example, my sister writes poetry, and I think she has copyrighted a few of them because she puts them online and uploads them. So if she were then to, because that means she owns them. If she were to leave those to me, and then and she died, and then everybody thought this poetry is fantastic, and it suddenly became really you know, valuable, or you know, similar thing might be with paintings, then yeah, all those royalties will come to me. I hope she isn't listening, but but yeah, so it's possible that somebody, their estate can increase in value, and as they go along, from those sort of things, from royalties or copyright or licenses, that sort of thing.
Right. Okay.
Or patents. Yeah.
Patents as well. Yes.
Yeah.
There is. Oh gosh, that's a big thing. Yeah.
Yeah. Yeah.
Okay. Well, just thank you so much. This has been an amazing conversation. This is the details are here now. If anybody needs to just get some more information from you, more detail, a personalized conversation, you know, with regards to their individual situation, they're quite welcome to contact you. Please get in touch. Absolutely. Yeah, definitely. Great. Okay. And can I also put your details on my website as well? Yeah. So that people in the future, so that's www.D.I.P.ism.com. that's D.I.P.ism.com. And also, maybe in the future, could we possibly have a conversation about probate? Would that be possible? Yes, absolutely. Okay, and repatriation as well. That's a really interesting one, yeah, and probably quite, you know, a bit more relevant in our circumstances as well. Yeah, absolutely, be happy to do that. Okay, brilliant. Well, Megan, thank you so much. We have gone over the hour, so I know, you know, time flies, doesn't it? But thank you so much. Okay. Okay, thank you very much. We'll end it there. I don't know, I'll just check and see if there's any last comments, but I know that we've got a comment from Maxine just congratulating us on a brilliant, Yvonne, on a brilliant presentation. Well done, ladies, from Maxine, and thanks, Yvonne. So thank you so much, Megan. I'll be in touch shortly. Okay, fantastic. Okay, take care. Okay, bye. Bye. Bye.